to date with everything that's happening. So the next thing is the permissible purpose for users to pull credit reports. And this is, again, what we were talking about earlier regarding permissible purpose or the impermissible access of credit to consumers. 15 USC 1681B provides the permissible purposes for users to pull reports. This requires a written consumer request that requires the consumer to sign or to acknowledge that they, in writing, that they have requested credit or to be able to pull the consumer credit report. And for the permissible purposes are for the extension of credit, for the collection of debts, for employment, for insurance, for assessment of investments, for instance, when a debt buyer comes, and other legitimate purposes. For instance, if you're putting in a car lot, and many other things. There are a lot of issues with it when it comes to the permissible access to credit reports, and these are the potential types of FCRA cases that are generated or that come in relating to possible the impermissible access to credit reports. So post-bankruptcy discharge, what does this mean? This means after a consumer has already went through the bankruptcy process and has had their debts actually discharged and has received an order from the court saying that the consumer no longer owes this debt, afterwards, if a creditor then pulls a consumer's credit report, they don't have a permissible purpose anymore post-discharge. After the bankruptcy takes place, the consumer no longer owes that debt, no longer has a contract or any sort of relationship with the creditor, and therefore the creditor does not have a permissible right or permissible purpose to access a consumer's credit reports. Additionally, post-debt settlement, so for instance, let's say a debt collector like Portfolio or LV&B or whatever, once you settle that debt with the agency, or once you settle that debt with a debt collector, and you've paid it off, they no longer have a permissible purpose to access your credit report. They no longer have a valid reason to be able to access your report. Again, mixed files and identity theft, but there's kind of loopholes. Car shopping and pre-approved buying, again, there are loopholes. And then there's a no dispute benefit. What does this mean? This means that you do not have to actually dispute the permissible purpose or the inquiry on your credit report if a furnisher or a user pulls your credit report and they did not have that permissible purpose or they did not have that right, then it's automatically a potential violation. So you don't have to send a dispute to the credit reporting agency or the user or the people who are pulling that credit report because they didn't have access or they didn't have the permissible right or the permission to pull your report in the first place. Again, feel free to ask questions. I'm sure a lot of these things are good. People are going to have a lot of questions. So feel free, as you have questions, to ask them on the chat. Objective inaccuracy. So this, we were talking about permissible access to credit reports, 15 USC 1681B. Now we'll be talking about objective inaccuracies, which is 1681I and EB, as it relates to the credit bureaus or the credit reporting agencies, and 1681 S2B, as it relates to furnishers, which in furnishers are the creditors or the debt collectors or whoever is reporting that